Welcome, everyone, to our Foundation Sexual Violence Prosecution series. Today, we're going to be talking about recreating the reality of the crime when it comes to our trial presentation. This is part of AEquitas's series. AEquitas is a federally funded nonprofit. We're made up of former prosecutors and other professionals. And our mission is to provide you in the field with innovative, informed, and hopefully really practical strategies that you can apply to the work that you're doing. We do that in a number of ways, including web-based and recorded presentations like this one, more formal webinars, and some written documentation or written documents, resources, case law compilations, all of which you can find online. We're also available to do any number of training events. So sometimes that is us going into a single office and providing some really tailored training to particular needs. And otherwise, we're also participating in national and sometimes even international conferences. We're involved in many federally funded partnerships and initiatives. I think one of the ones that's most relevant to our conversation today is going to the Sexual Assault Kit Initiative, where we partner with RTI and others to provide training and technical assistance to those sites that have received funding to clear their backlog or otherwise improve their responses to sexual violence. And probably Patti will agree with me, but one of our favorite things to do in our role as attorney advisor is to provide one-on-one case consultations. And we do that on demand. Oftentimes it looks like a prosecutor, struggling with a particular case that wants to soundboard some jury selection strategies or help develop a theme or theory for their case. And we can also do some peer-to-peer connections, including with experts in the field. So we're going to get started. But first, I will let you know that a lot of these resources and upcoming trainings we push out via social media. So please feel free to follow us on whatever platform you use professionally. The Office on Violence Against Women, part of the Department of Justice, funds this important work that we do. And while we appreciate all of their support, not everything that we say today can be directly attributed to them. We do use, and you'll see as we go through the slides, there's probably some citations or acknowledgement of other people's work. We do that under the Fair Use Doctrine. Okay, so let's get started. Patti, I'd love it before we go through the objectives for you to introduce yourself to everyone.
Thank you, Jane. It's great to be here today with you and with all of you who might have the opportunity to listen to this podcast. I'm Patti Powers. I'm an attorney advisor with AEquitas. Before I joined my colleagues at AEquitas, I was a senior deputy prosecutor in Washington State for 27 years. I supervised our sexual assault and domestic violence 3 different times during my tenure. And although I supervised our unit, I spent a great deal of my time in court in trial. And I mention that because I learned so much in that process, not only from my multidisciplinary colleagues, but also from juries and how juries respond to evidence and how important it is for us to really make sure that there's a connection between the victim's experience of the crime and the jury relating to their own experience so that they can better understand it. While I was still a prosecutor, I was appointed by the United States military as a highly qualified expert and had the opportunity to consult in addition on sexual assault cases as well as domestic violence cases and provide training both at Fort Leonard Wood in Missouri as well as in Germany. I was also a member of a multidisciplinary team that provided a great deal of multidisciplinary training in sexual assault cases. And we had the chance to go to Japan as well as provide that training. So I'm very happy with my career. It's fantastic working with my colleagues at AEquitas, and really a delight to be here with you today, Jane.
Thank you. And as Patti talked about, one of the things that we do when I'm discussing is how to connect with that jury and allow them to connect with the evidence from the very beginning and then throughout the trial. And one of the strategies is to conduct direct examinations in a way that you're really pulling upon the victim's experience to reflect the reality of the crime. And expert testimony can also help us do that. And so we'll talk about how they can support the work that we're doing and get us to guilty as we're moving forward in these prosecutions. So we're going to talk kind of jury selection, then direct examination. I'm going to pick Patty's brain about how experts can be used, how to effectively present medical evidence, and then, closing it all up with an effective closing argument. So lots to cover. And, this is just a conversation to lay some foundation, maybe to plant some seeds. So when we do close up, we'll make sure to provide you some additional evidence or additional resources that do maybe a little bit of a deeper dive here as well. So starting with this trauma-informed lens, I talk about that a lot when we're doing our work, that we need to see everything from the evidence to the presentation at trial through this trauma-informed lens. And that allows us to be better at looking at, okay, what does this testimony tell us? And what does this evidence tell us? So Patti, I'm wondering, when you talk about trauma-informed lens, what does that mean to you and your practice?
Well, first of all, we need to come to know and understand, to the extent possible, the victim's experience of the crime, because that really is the core of our work. It's the heartbeat of our case. And that is the evidence that we need to communicate directly to the jury so that they will not only understand the victim's experience, but what the offender's role was in committing that crime. So when we look through a trauma-informed lens, we really are using many skills involved in trauma-informed interviewing, allowing the victim an opportunity to articulate their sensory experience of the crime, related psychological aspects of that experience, and sometimes even physiological expressions of trauma that they might undergo. And this is so important in our ability to ensure that the jury has the means of connecting with that crime so that they can understand it on a deeper level and respond to it with the offender accountability that we're seeking.
So this connection, we talk about experiential connections and how we can connect the victim's experience once we have a understanding ourselves. How do we go into a courtroom and start to build that bridge so that the jurors are also making a connection with their own life experience that may or may not include, the experience of sexual assault, but other types of experiences that they can draw from to make these decisions and view the evidence correctly.
Well, although jury selection varies throughout our jurisdictions in our country, for those of us that have the opportunity in asking questions of panelists, what we want to do, first of all, is ensure that we're asking questions that allow the jurors, the potential jurors, to access their experience. And what we're also doing, Jane, is really establishing the infrastructure of the testimony that they're going to hear upon direct examination. So let me share an example. If, for example, a victim was unable, due to the impact of trauma, to disclose a sexual assault after it happened, and we know that most victims cannot and do not make immediate disclosures, but if they were not able to do that, the jury is going to have questions about that later on. So we're going to begin diving into this in jury selection with a question such as this: how many of us have been impacted by something terrifying or traumatic in our lives? And you look around the room and so many of the panelists kind of look at each other. You can see that they're thinking and wondering about raising their hands, but then the hands will come up. And the next question is going to be, I'm not going to ask you to detail something that was very frightening or terrifying or traumatic in your life, but I would like to ask you some questions if you're able to provide some information. And what we hear from jurors at that point, potential jurors, are involvement in serious accidents, victimizations of serious crimes, witnessing serious crimes, sometimes military service. The examples really are legion. The next question, the follow-up question is, if I might ask you, is this something that you were able to talk about right away, or did it take you some time to kind of square it in your own mind? And very frequently, panelists would respond, I couldn't talk about it for days, weeks, months. And sometimes the answer was never. I've never really talked about it until I was in this setting. And so what we're really doing is giving them an opportunity to really connect with the victim's testimony when they hear it, about how difficult it was to come to grips with that sexual assault and really believe that it happened to them when so much they did not want it to happen. And so this is only one of many examples that we're happy to share with you in planning jury selection. But the key is allowing the jury a chance, when they hear the evidence that we present during trial, of utilizing their life experience to understand the experience of the victim.
I muted myself there. I apologize. I think it's really powerful too, because I'm already thinking they might not even kind of know why you're asking that question during jury selection. But then as you present the evidence and then as you close, you sort of bookending your case with, again, referring back to this common experience of trauma and of disclosure and the ability to disclose. You're so clever.
I'm sorry, Jane.
No, go for it.
Let me follow up on that a bit. Usually when we begin jury selection, we're going to ask questions about the nature of the crime. They're going to be advised by the court and again advised by counsel. This is a crime of first-degree rape. And so they know what the crime is, and then there'll be a series of questions. We anticipate evidence of violence. For example, is this something that you believe you'd be able to handle in stride with your fellow jurors, and listen carefully to all of the evidence, no matter how difficult that might be for you. So those questions are really building up to the trauma questions. And another thing that's so important about that is we're establishing that this is a crime involving trauma. So I think it's just, there's so many important strategies that we can bring to jury selection.
And you talked about your work and how presenting that trauma, you're not just asking, the what happened next type of questions, and then what happened, and then what happened. And we talk about in some other parts of this series why even sequential questionings might be problematic, but more so, I would love it if you could delve in a little bit more why it's important to present evidence of sensory memories and psychological, and you mentioned physiological as well as the physical experience, and how this recreates the reality of the victim's experience.
Well, what's so important about a trauma-informed interview is allowing the victim a true opportunity to discuss their experience of the crime. And this is the kind of information that victims have an ability to access. So it is a very trauma-informed approach, and it allows them the chance to be in touch with their experience of the crime. Some victims may or may not be able to provide peripheral detail, such as what time it was or other events that might have been surrounding the crime. Certainly, they're very focused on a crime that they did not want to happen. So they're intensely focused on the experience of the crime. When we ask for sensory details, this allows the victim the chance to describe what they saw and what their experience of that sight was as the offender moved towards you. As you've described for us, were you in a position to see his eyes? I was. And how did his eyes look at that point as he came looming towards you, as you've described? And so many victims would describe the eyes of the offender as mean, ugly, angry, violent, hateful. the list goes on. But all of those words went to the impact of fear, the betrayal, for example, if a victim had been in a relationship or an acquaintance with the offender. And then we'll ask them, as he approached you, as you've described, again, this is double and triple direct examination using a response as foundation for the next. We'll ask them, how did you feel when you saw his eyes looking like that? I was terrified. I'll never forget how his eyes looked. And it's interesting because I've so frequently seen the jury look over toward the defendant, trying to see what his eyes look like then. That's how engaged they are in that kind of sensory detail. And then ultimately, when you saw his eyes looking, as you've described them, as being violent and how afraid you were, are you able to tell us how that felt? And victims, if they're able, are going to describe physiological responses as well. My heart stopped beating, or I thought my heart was going to pound out of my chest, or there was a darkness in the room, it seemed, even though I think the lights were still on. Now, as we're presenting this evidence, our fellow citizens who are jurors over there are listening carefully, and they're using their senses. They're thinking about how they would have responded, how they would have felt. And when we're able to do this, then we really are connecting the jury with the victim's experience of the crime. And that is critical to offender accountability.
And you mentioned it, but I want to make sure everyone heard you, which is these questions about how their eyes looked. Like, that isn't just a question for a case that involves an offender that is unknown to the victim, but it can actually be sometimes even more impactful, probably, when that offender is known to the victim, but their eyes in that moment looked so very different than the person they thought they knew. And this sort of making this, even the known offender, describing them as a stranger in that moment, a stranger to the victim in that moment, I think can be a really powerful way to sometimes break down what I think is a common myth or misunderstanding, that the known offender may not be as dangerous, or the trauma may not be as impactful to the victim because there's this relationship. And the way that you present that is, this person is now a stranger. I didn't recognize their eyes. Their face looked distorted. Those things could just be really powerful sensory details that can connect. Okay, so you and I think I stole this from you. I now feel like it's mine that I've stolen from you. But I know both of us really like to talk about this. I know it shaped the way I did my work, was when I started using this word able in different ways, but I thought maybe I'd hear it from you, the OG, talking about the power of the word able and how we use that effectively.
Well, it's so important. And you made a great point earlier, Jane, when you talked about, we don't ask victims to provide chronological detail. What happened next? What did he do right after that? They'll do their best to provide us with information, but they don't have the chronology. That was taken away due to the impact of trauma. So when we ask that question using the word able, what are you able to tell us about what happened? We're conveying so much in that question. We're essentially telling the victim, we know it was traumatic. We know you had a terrible time. We know that it's vastly impacted your life. So please tell us what you're able to about what happened. That really conveys our understanding and our compassion to victims as well. That word is also the infrastructure of trauma. And we use this also in direct examination at trial, which conveys to the jury, again, the victim has gone through a horrific and traumatizing event. And so we're now asking what she is able to tell us about that experience. So it's a critical word for us as professionals. It's a great word because it takes away the legal pad with the outlines, and it puts us right in the flow of a narrative with the victim. And we will not be interrupting, but following the narrative of information that the victim provides, and when appropriate, asking follow-up questions. This also is a more effective strategy at engaging the jury in the conversation that we're having. And I think that's really one of the most effective direct examinations. It's a conversation and allowing the victim as a witness to describe the experience.
And I think it does take a certain amount of sophistication and confidence to design your direct examination that way. I think when we're in law school or whatnot, we want to write down all of our questions in this sequence. But when we do that, first off, I think we're more focused on this list of questions in front of us instead of actually listening to the person and their response and engaging in that conversation. So when we're able to, I agree that maybe to have, like sort of topics that you want to hit and use that instead of using a really strict, almost script that we sometimes do in really technical cases. I know that can be a little bit more important if we're doing chain of custody kinds of direct examinations. Maybe we want to use that. But I think this magic word of able, sometimes victims, especially if we're, they're trying to help, they want to be believed. And if we ask the same question, maybe even twice or multiple times, you may even get a situation where a victim is trying to fill in and trying to answer something, and they don't actually know. And then you're going to get yourself in more trouble. So sometimes I'll use the example of, what color was the shirt? And then that again, well, can you remember what color his shirt was, or what color was the shirt? And then you have someone sitting there going, I want to tell Patty, I want to help Patty. I know it was dark, maybe it was blue. And instead of saying something like, you able to remember the color of the shirt, it really gives that person the permission, and also tells them that we understand if they're not able to. And I think that same thing happens when we ask those questions in front of a jury. We're kind of setting expectations for a jury that not only will they maybe not be able to answer all of our questions, maybe not be able to answer all of the defense attorney's questions, but also that inability is because of the trauma that the offender inflicted. I know I'm giving this word a lot of power and it is magical.
It is. I agree.
Those things. So we love that word, for the record. Let's see. So if you could walk through some of the key parts of the direct examination.
Sure. When we commence the direct examination, we need to introduce the victim to the jury, much as we would want to be introduced if we were in a similar situation. And that means allowing the victim an opportunity to tell about their background, for example, prior educational history, if that's appropriate, whatever background information is necessary to allow the jury to come to know the victim. And we're going to begin really with the context of the crime, and bearing in mind that the crime itself is going to be the focus of our examination, but we're going to begin, if it's appropriate, with the day in question. What were the victim's activities on this particular day? If the victim is working, at what time did the victim get up? Did she have coffee? Did she go to work? What were her activities? And then if there is a known offender, certainly, we're going to be asking about a contact with the offender. What was the expectation of that get-together? Was there a discussion about going out to dinner, going to a movie, going to a tavern to have a drink? But what was the expectation? We're going to weave into this also signal aspects that we're going to utilize on cross-examination if the defendant takes the stand. And one of these will be who had initially made that decision about what restaurant to go to or what tavern to go to. or what to drink, to have dinner, to not have dinner. Again, evidence that's appropriate to the case. Then as we segue into the crime, we're continuing to draw through any control features of the offender and contrasting those to the victim's expectation of that contact. When we get to the victim's experience of the crime, we want to allow the victim a chance to give voice to all of the fear, all of the trauma that the offender caused in the sexual assault. And we'll ask about what the victim saw, what the victim heard, tasted, or smelled as appropriate. Then we'll ask about the attendant emotional response. How did you feel when he did that? And then finally, physiological details if the victim is able to share those. I'll offer an example from a trial. A victim testified that the offender held his hand up to her throat, much the same as I'm doing here. This is what she demonstrated from the witness stand. And I asked her, as he held his hand up to your throat, as you've described, can you tell us about your experience at that time? And she described how she could almost feel his hand all the way through to the back of her neck. Now, we knew that his hand did not penetrate her neck. She did not have that injury, but that was her experience of a traumatized sense of touch. And that's how compelling it was. And then I asked her, as he held his hand up to your throat, as you described, and you sensed it on the back of your neck, are you able to tell us how you felt at that point? And she responded, I thought he was going to kill me. I thought I was going to die, as most victims of sexual assault testify, regardless of whether this is a known or an unknown offender. And I asked her then, repeating that same information, and that's triple direct examination for foundational purposes. I asked her then how that felt, and she did say that she experienced a darkness in the room, but she thought that the lights were still on and that her heart was pounding. She was worried something was going to happen to her. Allowing the jury an opportunity through the foundation that we laid in jury selection, as well as through this evidence, to put themselves in the victim's position to try to understand that testimony. And then at that moment in time, as she discussed, someone that she believed that she knew became, as you said, Jane, the stranger, and the stranger was a rapist. And that's so compelling for jurors to try to understand the level of trauma involved in this crime. And life changes for many, if not most, victims. Many victims are involved in a lifelong process of trying to recover the sense of self that they had before the sexual assault. For some victims, that process simply doesn't end. Many victims will decide that they're going to leave the area. They might work in a different office than they had previously. There are many changes involved. There may be changes in security at their residence, or they may virtually leave. Life is going to change, and we're in a position to draw some of the relevant aspects of that after the disclosure is made. And so what we're doing, again, relates back to the jury selection process that we've been discussing, but we are now recreating the reality of that crime through direct examination.
Yeah, as you described how this testimony unfolded, I had a visceral reaction, having never experienced that, but there were parts of it that I absolutely connected with. The darkness in a light room, or the feeling like something was deeper than it was when I experienced, just an injury or something like that. So it's very visceral. I can see how that would connect. I do have a follow-up question, because I have also seen cases where it's like life hasn't changed after the rape, where a victim has tried to their best of their ability, return to normal and almost try to sort of pretend this didn't happen, where they're going to work the next day. They're not telling anyone. How can you describe that sort of response, as well as maybe something that we would expect, which is that daily life would be interrupted in really meaningful ways?
I think that's a great question, Jane. And what we're really talking about is that there may be a myriad of ways that victims respond to trauma of the crime. As you just mentioned, a victim may be doing everything humanly possible to try to recapture the way life was before the sexual assault. And that means going to work the next day, not even taking a day off, but being there, continuing to do other activities. And in that process, you can actually see there's sometimes a desire that this crime never would have happened, and trying to get back to a reality that was so much more comfortable than the reality they're forced to live in due to the crime. And I think this is very compelling as well, because what we also have access to are going to be a number of secondary witnesses who may also be able to testify to changes in the victim's demeanor that next day at work or during those other activities, differences in attire, differences in interaction in social settings. So we still have witnesses that can speak to some of the other differences. And then we have the very compelling testimony of the victim who is trying so much to get on with her life, but having considerable difficulty in moving forward after what's happened.
Especially if, the case is coming to us, then assumably there was a disclosure at some point. And so sort of like the question being, well, not why did you never disclose, but what prompted you to disclose now? And I can imagine an answer being like, well, I was trying to hold it together for a really long time. And then eventually I realized I couldn't, or I learned something that made it known to me that this person was dangerous and maybe could harm others. There's usually some sort of prompt. And so getting at that might be helpful too. Okay, so the goals of direct examination, and there's a number of them, which of course is trying to tell the whole story. I think we focused on some of those experiential details that can be so powerful. But I also want to talk about some of these other goals, and maybe we can go through them a little bit. The idea of corroborating every detail, because we might not have, an eyewitness to the assault, but we can't fall into the trap and the myth of the, victim says, offender says, and I guess we have nothing else to rely upon, because that's not usually true, is it?
No. Yeah, and that's a great question, because as we both know, in many jurisdictions, a victim's disclosure does not require corroboration, the disclosure of the crime. But we know that our fellow citizens who are jurors are looking for evidence to corroborate various aspects of the crime. And it really can help us develop more context as well. In addition to the victim's very powerful direct examination, we potentially have a number of other possibilities with secondary witnesses who can establish, for example, that the victim was with the offender on this date and at this time. Perhaps a witness in a tavern can provide information about the length of time that they were there. Maybe another witness in the party or another individual working in the tavern can talk about having their attention directed to the victim who seemed to be impacted by some of the alcohol that was being consumed. And so what we're really doing from the disclosure, we're kind of spanning it out into the greater context. And we can also find witnesses who can support various aspects of it. And I think also another important consideration for that is we're establishing further the diligence of the investigation. And that's very important for the jury's consideration as well. Our investigators did not leave any stone unturned. They looked at all of these other possibilities and followed all of these leads in an effort to present the available totality of evidence to the jury.
Yeah, we've got another conversation that I had with our colleague John Wilkinson about collaborating with law enforcement. I think this is one of those things where not only do we demonstrate to the jury the diligence of law enforcement and trying to corroborate, because nowadays we know not only are there, live witnesses, but there's electronic receipts and surveillance videos and, this an Uber or a rideshare records. There's so many things that we can use to corroborate those details. But I think when we do that really full investigation, we're also showing and demonstrating to the victim how diligent and how holistic our response is. And we know that we're always striving to establish trust and rapport, and how much more, what is a better way to do that than to demonstrate we're going to fight and we're going to look into every single detail and try to corroborate and try to preserve and document all of this other evidence that we can. Then the last one I want to talk about while we're talking about these overall goals is maybe a bit of a shift, which is this idea of one of our goals being to create empathy. And while we're working with victims of sexual assault who hopefully we're all empathetic to the trauma that they've experienced, sometimes we do have victims that maybe our jurors might not have immediate empathy for. And so how do we, as prosecutors, kind of overcome, and I hear this language, and I have to admit, I probably used this language at some point, which is like, I have an unlikable victim. I have a victim that I don't think the jury's going to get or relate to, whether it be that they are, which is ironic to me, justifiably angry that this happened to them, or maybe this is a victim that has a substance use disorder or has engaged in commercial sex work, which of course are vulnerabilities that the offender preyed upon, but still we have to worry about, okay, how do we present and create empathy when our victim doesn't look like our jurors want the victim to look, if that makes sense.
It does. And that's a great question. And I think that this process begins early on for us as prosecutors. We need to get to know victims. When we talk about establishing trust and rapport, you and I know that this doesn't happen in one meeting with the victim. It comes throughout a process, through the development of that kind of relationship. In this process, we come to know the victim. And as prosecutors, at the heart of all of our work is compassion and respect for our shared human dignity. We really are all in this together. The victim has entrusted us with the great responsibility of giving voice to their experience of the crime. And it really is a privilege to do that as a prosecutor. So I think it does begin with us as prosecutors. And once we've established that kind of connection that we're discussing now, it becomes much easier to convey this to a jury. And we do it in a number of different ways. We do it through our demeanor, our body language, the respect that we are basically expressing through our direct examination, how we react to responses, the level of understanding that we're demonstrating to the jury in our both verbal and nonverbal responses. All of those can add to the jury's natural inclination to want to be empathetic. Sometimes it could be more challenging than others, but that inclination is there if we give the jury an opportunity to come to know the victim as we've come to know the victim through the professional work that we're doing.
I love that. And it's funny because if you've ever talked to a jury afterwards, you learn very quickly how much they're observing in the courtroom. Everybody's little interactions with each other, body language, facial expressions, they pick up on all of that. So to be able to really recognize that it's our nonverbal communication with the jury that can be powerful as well. And I think it's also a good segue for us to talk about the jurors' expectations being kind of over here in all of these strategies, really trying to connect that with what might be the reality of the case that we have over here, and pulling that together, because of course that's going to be one of our jobs, and we can do that in lots of different ways. But I want to talk to you specifically about what I think is probably one of our greatest tools in our toolbox, which is the use of expert testimony, and in particular, this idea of the blind expert who is there to provide education to the jury based on their experience and expertise, usually working with other victims of trauma and other victims of sexual assault. So I don't know if you want to work with me here and go through why expert testimony is so such a powerful tool in our toolbox.
Okay. I think the starting point is based upon our working with the victim, we need to come to understand basically a victim's ability to describe the trauma that they underwent and what their responses to trauma were. There are some victims who are able to do this, and we can proceed without an expert in those cases. There are other victims who have some difficulty in explaining the depth of their response to trauma. And it's interesting, here's another point that relates back to jury selection that we've been discussing. One of those follow-up questions on trauma would be, were you able to understand how you felt after this happened to you as you've described it? So many panelists would say, I couldn't even imagine, I couldn't do anything. I couldn't be in relationships, as an example. And they'll go on and on. Did it help to talk to somebody to help them sort this out? And what we're really doing, we're talking about expert testimony coming up. And the infrastructure for the expert testimony is still going to be the victim's testimony. And the victim may provide information. For example, I sent a text to this person the next day, and I had questions to ask him. And we might ask, are you able to tell us why you were in contact and how it was that you had questions? And I can recall victims describing really what was very traumatic. I just didn't want to believe that this happened to me. I couldn't believe it happened to me. I thought that maybe if I contacted him like that, I wouldn't have to see him because I couldn't see him. But if I sent him a text, maybe he'd say, did you have a really bad dream or something? Nothing like this ever happened. That's the impact of trauma. And a victim may be able to describe that to an extent, but an expert can give us more context as we're discussing, and talk about what coping is, and talk about the impact of trauma and trying to recapture a better and more comfortable reality before the crime occurred. And so expert testimony based upon the infrastructure of victim testimony in this regard can be very important for juries. We also have, and it's a wonderful federal rule that's incorporated into all of the states that I'm familiar with, we have the ability to ask evidence-based hypotheticals. And what we can do in many jurisdictions is to ask an expert to assume, for the purpose of testimony, certain aspects of trauma, and then to render an opinion if, for example, this is a common or uncommon expression of trauma. And what's amazing about that particular strategy is that we can actually be referring to evidence that the victim has already provided, but we don't couch it that way in an evidence-based hypothetical. The jury's heard it though, and they know what's there, and they're connecting those dots. And when we allow the jury the chance to connect those dots, we're really engaging them again in the victim's experience of the crime.
Here, we have here this idea of this testimony being able to support victim credibility. And I want to be really careful of the language we use here, because this is also one of the danger zones if the expert is vouching for the victim or somehow opining that the victim is in fact a victim. So, but there's lots of good case law that says, it can support and it can provide the lens through which a jury can then make those credibility determinations. So for example, there are cases where victims not only, text maybe the offender the next day, but in their efforts to sort of regain normalcy and sometimes regain control over their own bodies, they will actually engage in consensual sex with the offender after an assault. I think that's probably, I'm using it to talk about one of the more challenging facts that we may have to deal with. But if we've done this work long enough, we realize that that is not incredibly uncommon, and that there are psychological reasons why that may seem like a good idea to the victim, and their brain is telling them that. And I'm probably butchering all of this, but all of it to say that alone, the jury's not going to be able to understand that
Right.
victim response. And so that might be a case where we do need to bring in an expert who's able to say, hey, this is not actually that uncommon, and here are a few reasons why we know this occurs more commonly than you might think. So that other side of the coin of that is, dispelling these misconceptions about, what people should or would do in traumatic circumstances. Because if we don't dispel them, in either through effective jury selection, effective direct examination, we have lots of tools, but expert witnesses can also be one of those tools to make sure that our jurors aren't relying on those myths and misconceptions we know are really prevalent out there in our society. So this is a go-to question for you, and I know you're going to be so diplomatic. But when we talk about who are we going to bring in as an expert, and there's lots of different options. So do you fall on one side or the other about having, an academic that's maybe engaged in some research and has a neurobiology background or psychology background versus someone who's maybe worked in rape treatment centers and worked directly with victims over the years?
Well, I think what we're looking for is an expert who does have academic credentials, their level of education, but also who has experience in the area. Now, academic credentials don't necessarily need to be PhDs. It all depends on education appropriate to the work that this individual is performing in the community. Experience is always great. That is probably one of the strongest features that an expert can bring to their work. It may be an investigator with many years of investigatory experience who has worked with hundreds, if not thousands, of cases involving complaints of sexual assault and is familiar with delayed disclosure, is able to define it, is able to talk about the different features of delayed disclosure, and is able to further offer an impression that this is a common response to a sexual assault. And as she mentioned earlier, Jane, it's important not to invade the province of the jury. So using that example, there is not any mention of credibility of the disclosure, but talking about, as a general expert would, that feature that is common in many, if not most, cases of sexual assault. So looking back at this, whatever academic credentials are appropriate to the work that is being done, I think experience is probably the stronger feature.
And I think it could depend on your case. It could depend on your jury panel. It depend on geographically where you are. We sometimes talk about a specific example where somebody was in a very rural area and brought in an academic from, an Ivy League university, and the defense really was able to effectively sort of make the argument of like, hey, we live in this community. This is our community. We don't need somebody from an Ivy League coming in here and telling us what to do or what to think. So that's probably an extreme example, but I think there's just a practicality as well as of who might be a good fit for a jury. And also there's obviously considerations of price and things like that. But this is probably one of the things that AEquitas helps out with more than others, of providing referrals for who might be a good expert for a particular case. And so shout out AEquitas and a little advertisement there. So these are some of the questions of how we might pose these questions to a general expert. Are you familiar with, is it common for, or what are some common reasons? What are some reasons that a victim might do X, Y, and Z? So these are just a couple of questions that we put out there to help you frame and develop what a direct examination of an expert might look like. We also want to make sure that we're using our other experts and medical evidence and expertise. So we want to be using our SANE or our medicals to explain the exam that's going on, to report their observations. The physical evidence may come in the form of a photograph, or maybe we're looking at swabs that have been tested for DNA. And then we may also be using the same witness, and this is sort of unique for medical experts, where they may be a fact witness and they may be an expert witness, or we may have two different witnesses. And so this is another place where really important for us to get it right, and can inform how the jury is viewing this evidence. And if they're being used as an expert, it's findings based on their observations or significance of those findings. I don't know, Patty, in your practice, was it usually the same witness that was both testifying as to, the exam itself and then the findings or the significance of the findings?
Usually it was. The SANE would testify to the examination that was performed, and specifically in most cases that there likely were not abnormalities that were formed, but the history was consistent with those findings, and then explain that. In addition, the SANE would also be a necessary witness for the chain of custody if a sexual assault kit was taken with the consent of the victim. Those swabs were sent to the state crime laboratory. So this is part of the chain of custody. And then a forensic analyst from the crime lab would testify as to the work they performed with the DNA and what their findings were. And you mentioned earlier, Jane, that one of the initiatives that we work on is the Sexual Assault Kit Initiative. I want to mention how important it is as prosecutors that we ensure that when a victim consents to a sexual assault kit being taken, that kit is tested. I know in many jurisdictions there now is legislation that requires that be done. But looking back to the past, and one of the reasons behind the backlog of cases, not always were sexual assault kits sent to crime laboratories when this was a known offender. But it's so important that this evidence is presented in cases involving known as well as unknown offenders. So in these cases, when the victim is willing to present for that medical evaluation and the sexual assault kit, we need to ensure that it is timely sent to the crime laboratory, and that we call the forensic scientist to testify as to the results of it. If there is a finding of DNA, and if that is the DNA of the offender, regardless of whether the offender said that there was consensual sex or not, that evidence needs to be presented to the jury. If there is not evidence extant from those swabs, as an example, we still present the evidence from the forensic analyst. It's so important that the jury knows all of the care that was taken with the victim's experience of the crime to bring it forward with the charges. And regardless of whether there's a DNA finding, it still is important that they know that this was done and what some of the features might involve not having a DNA finding in this case.
Absolutely, and you're saying and can help you with that. Your analyst, and I think it's also important to really, again, recreate the reality from the perspective of the victim who
Yes.
did in fact go and receive medical attention, and to better understand what the role of the SANE is. I think we too often think about and even present it as, oh, this is just part of a DNA collection. That's all that this is, right? That's what the SANE does, is they collect DNA. And if you work with your SANEs and your medical professionals that do this work, you'll find they're some of the most amazing professionals I've ever worked with. Incredibly humble. They have a ton of information. They can share how that exam looks, the amount of care that they take to explain it to the victim, to go through the different pieces of consent, the education that they give the victims, the aftercare that they provide to the victims, and presenting that to a jury is also, I think, really impactful. Side note, may or may not be related, but if you could put a nurse in front of a jury, I think that's a great thing. Nurses have been voted year after year as the most trustworthy of professionals. So I always love to nurse on, although I do think I would also say, don't assume that they testified, that they're expert when it comes to, testifying in cases, even though they may be listed on hundreds or dozens of cases, they don't necessarily testify a ton. So I say, work with them, work around their schedules, which are often a little bit crazy, and make sure you give yourself plenty of time to speak with them and have them educate you leading up to the presentation of their testimony. We could have a whole thing on just this slide itself, Patti. We may as we go through that. But as we're closing out, we're also going to give you the opportunity to share your key pieces of what do you think makes an effective closing argument after we've done all this work leading up to it.
What comes to my mind immediately, Jane, is a sense of honor that I had as a prosecutor, and I know that my fellow prosecutors around the country have as well. At that moment, when we rise from counsel's table to approach the jury, what we're doing is advancing justice in this case. We're giving voice to the victim's experience of the crime. We've taken a deep dive into that evidence during trial preparation. And further, what we've done is to elicit all of the appropriate and salient evidence at our disposal as we have built this case. At the heart of our presentation has been the victim's direct examination, which has brought forward to the jury the victim's experience of the crime, replete with all of the details that we've been able to describe. And so this is what we bring home to the jury in closing argument. We first and foremost are going to reveal the summary and the impact of all of the evidence that's been developed in this case, all relating back to the victim's direct examination. The members of the jury are also going to have in their minds at that point the very carefully put together jury selection questions that allowed them to access their own experience. And so as we fold in all of the victim's experience, the sensory details, the physical responses, the psychological responses, we're building that connection with the jury. In this process, we're also going to provide their infrastructure for consideration of the evidence, referring to appropriate instructions and what they're required to do regarding the elements of the crime. And as we do this, we're pointing to the evidence that establishes that element beyond a reasonable doubt. And so thanks to our ability as prosecutors to make this closing argument, there really is a sense of amazing respect that you feel for the resilience and the strength of the victim in making this argument possible. And so first and foremost, I think that really is the key to an effective argument. Having worked with the victim over an extended period of time, as well as other multidisciplinary professionals who have supported prosecution, we have a deep understanding of all of this evidence, and we've presented it to the jury, helping them to connect. At that moment, we're in the best possible position to ask them to impose offender accountability based upon all of this evidence.
Thank you so much for sharing that. And I'm sure many of the folks out there listening would love to pick your brain about, fact specific cases, or I've got this case that. And so that'll be another plug for reaching out to AEquitas and engaging in Patti or our other attorney advisors that do that one-on-one case consultations, because as much as we can talk about the keys, we know a lot of this is fact specific and depending on the evidence that you've been able to present. So as I thank Patti for having this conversation with me today, I think going forward, we all can have a better understanding of not only why it's so important, but how to maybe start laying the foundation for our cases as early as jury selection by making those visceral or common experiential actions, and then pulling that all the way through our direct examinations using our magic word, and then introducing those experts so that if we've got something that still needs explaining, that still might need a better understanding and some expertise from the field, whether it be medical evidence or evidence of common responses to trauma, that we're engaging experts throughout that process. So lots of additional resources. You'll see most of these involve Patti and her partners on the SAKI, or Sexual Assault Kit Initiative project. I encourage you to reach out. I encourage you to check out some of these resources that do a deeper dive. And then one last plug, and that's for AEquitas's office hours. The third Thursday of every month from 2 to 4 on Eastern time, we pull together prosecutors from around the country. Welcome to register on our website. Different topic every time we do it, always in the realm of, how to better respond to crimes of domestic violence, sexual violence, stalking, and human trafficking related crimes. Opportunity to share strategies, to maybe talk about emerging trends that you're seeing, and really just to foster those peer relationships so that your, that conversation you have in the lunchroom is even bigger and can be done on a national scale. So thank you, Patti. It's been a pleasure, and we'll see you next time.
Right. Thank you, Jane.
Okay.
So we've done it.
Need to stop the